Well, thank you very much for having me here today, and thanks a lot to the audience for showing an interest in the EU initiative on the revision of its design legislation. So thank you very much. I also want to thank Peter for his very interesting presentation and for being willing to participate to this event. I would like to go to the next slide, please. So, as Peter probably already mentioned to you, currently we have a directive and we have a regulation on designs. So what is a directive? A directive harmonizes the national laws. So that means that it aims to make sure that the laws in the different member states of the European Union, that they are harmonized. The directive stems from 1980. So that's actually quite old. And the regulation, which came into force a bit later in 2002, actually is directly applicable in the EU and concerns EU designs. We call it, back then it was called a community design. Now we would call it an EU design because it gives a right that is applicable in the whole EU, whereas the national rights, of course, or regional rights, as is the case for the Benelux, these rights, they only apply to that particular territory. So this is quite old, and we're still working actually with this legislation. So it's really time that we now get started and come up with an amendment to this existing legislation. So actually this was announced in our IP action plan, and the actual IP action plan was announced in 2020. Not only the design law is going to be reviewed, but also many other areas of IP law are going to be changed. For example, also in the area of SPCs, of GIs. Patent law is going to be revised, and then not so much the unitary system, but for example, standard essential patents. So we're working on many different initiatives. What we already did before the IP action plan was announced is that we did an evaluation of how the design protection system in Europe is working. And the results you can find if you click on the link of the presentation, which I assume you received. You can read the report and its findings. Within the framework of the evaluation, we had a public consultation, and we used the input of that public consultation for drafting the evaluation and its conclusions. We also based the evaluation on different studies we had commissioned earlier. We then later on, after the evaluation, had another public consultation that was a bit more asking specific questions about specific topics. For example, also the overlap or the accumulation of design protection with copyright law, on which I will speak later. We have been drafting our impact assessment. The impact assessment is actually describes what the current problems are in the design laws, legislation, and how these could possibly be solved, and what our objectives are with our new proposals. So this actually we drafted last year, and it was approved internally by the European Commission. It's not published yet. We hope to publish this soon. For that reason, I cannot give you all the details yet. But nevertheless, I will tell you what we've been doing so far. We're currently working also on the new text of the directive and the regulation, and also this we hope to publish soon. Next slide, please. So what were the findings of the evaluation report? Of course, you can read it, but I will give you a short update. So actually, it turned out that the system as it is currently is actually working very well. The stakeholders who replied to the questions, they were actually quite happy with the current system. However, of course, when it's 20 years old, there are always some shortcomings. And some of these shortcomings I will mention now. So as the directive, so the one that is harmonizing the national laws, never gave any rules on how procedures should be harmonized, it turned out that in the different national laws, the procedures were quite different. And of course, this is very inconvenient for users of the system, because if you are not only using, let's say, the Benelux as the area where you want to have a design registration, but also in Germany and France, then you have to be aware of all the different procedural rules in the different countries. So this is something we need to tackle. Another thing is that some procedures, for example, also on the EU level, so for the EU rights, we're not very, we're a bit outdated. For example, we still have the possibility for paper filings. You can only still, till now, only register a static representation of your design, so not a 3D one. So things need to be updated and modernized a little bit. Then one of the hot potatoes we have in the area of designs is something that still has not been resolved, and that is the fact that spare parts for the repair of automotive of cars are in some member states of the European Union protected as a design, whereas in other member states they're not protected as a design, meaning that in some member states, others than the IP right, the design right holder, are not allowed to produce that design, whereas in other member states they are allowed. So meaning that more competition is possible. So this is also something that needs to be tackled and needs to be harmonized. Then it is also true that some definitions in the EU legislation are not terribly clear. They need to be clarified. And what we also learned is that especially the renewal fees were considered a bit high by certain users, especially for small, medium-sized enterprises. So next slide, please. So, like I said, in our impact assessment, we also have to indicate what the objectives are we want to achieve with our new legislation, or amended legislation to be precise. So what we want to achieve is that we bring the single market for spare parts closer to completion, because now what we see, like I said, is some member states protect these designs for spare parts and others don't. So we want to harmonize this. This is one of our aims. Another aim is that we want to make the system for union designs more accessible and efficient for individual users, especially for small, medium-sized enterprises. And another objective is that we want to enhance the complementarity and the interoperability between the community system, so the one for the EU rights and the one for the national rights. Because, like I said, especially procedures were not harmonized on national level, so this should be harmonized. And what we aim is that we try to harmonize it also with the EU system. So we also try to bring the EU system and the national laws closer together. Next slide, please. So how are we going to do that? So we're exploring in our impact assessment different options on how we could do that. And then in the impact assessment, we describe what the possible impacts of all these different options would be, and then decide which option would be the best to solve the problems that I just mentioned. So what we will explore is how to best harmonize the laws on spare part protection. We will also explore how to streamline and simplify the community designs procedures. And what we will try to do is also align these procedures with the procedures that we've established for the EU trademarks regime, which was harmonized earlier. So this was done already some years ago. To make it also easier for people who also file trademark applications, to make it easier for them, because if the procedures for designs would be more or less the same as for trademarks, that would of course make it much easier for the users. We also will try to adjust the fee levels and the fee structures of community designs, and we will try to harmonize the national laws and align them with the community design system. Next slide, please. So what actually are spare parts? You may be wondering, no, because I haven't explained that to you yet. Here you can find some images of spare parts. You will see, for example, it can be the door of a car, it can be the window of a car, or be the hood of a car. And it's important that these spare parts, that they protect, actually these are spare parts that protect the outer appearance of a car. So not the ones that you cannot see. And they must also must match, of course, because if I'm driving a BMW, I cannot put a different the hood of another car on that if I want to repair my BMW, you know, because I had an accident and the hood needs to be repaired. I cannot then use the hood of, let's say, a Mercedes. So they must match. So that also means there's not much choice for the person who's repairing the car. He must necessarily buy that particular spare part. Well, what's also clear is that in some member states, these spare parts are protected, meaning that only the right holder of that particular design can produce that design or give licenses, whereas in other member states, other people can use it as well. The problem if the right holder can only produce these, can only produce the design, means that also others cannot design around, because like I said, it must match. I cannot design a slightly different door because then the car looks ridiculous. Next slide, please. So now I will tell you a bit what the current legislation says about spare parts. In our community design regulation, there was a repair clause. And that repair clause actually says that already on the level then of community designs, that actually they cannot be protected, these spare parts. So for community designs, spare parts cannot be protected at this moment. The situation, however, is different on a national level, where we have a so-called freeze plus clause. And actually this clause says that the existing laws can continue, but if you want to change your law, so regarding the protection of spare parts, you can only do this to abolish protection for spare parts. You cannot, if, for example, currently or at the moment that the directive came into force, if at that moment that particular member state did not protect spare parts, then that particular member state could not change it and say we are now going to protect spare parts. It was possible, however, for those member states that did protect spare parts to change the law and to decide that actually spare parts cannot be protected. So that was the situation. And in the meantime, a few member states have changed their laws, meaning that in those member states, spare parts can no longer be protected. Next slide, please. Like I said, in some member states they are protected, in other member states spare parts are not protected. We already tried in 2014 to come up with a proposal to change Article 14 of the directive. However, at that moment there was no support. It was blocked especially by Germany and France, where the automotive sector has quite an important role to play in the market for their internal markets. No. However, in Germany, quite recently, in December 2021, they have liberalized the market for spare parts. So now spare parts are no longer protected. And France also liberalized the market a bit less radically as in Germany, because it's only sectoral, but also they're no longer protected. Next slide, please. So what is the consequence of the fact that these spare parts are not protected the same way in the different member states? Actually, this is of course very bad for the internal market, because it's very difficult to then, for example, produce spare parts in one country where it is allowed. I mean, to be produced by somebody else than the right holder, and then exported to another member state where actually they are protected. So this is, of course, problematic for the internal market and for trade. It leads to a lot of legal uncertainty, and also it means that in those member states where spare parts are protected, other, let's say, garages and producers of spare parts, they cannot compete. No, they cannot do anything. They can only produce or repair the parts of the right holders. This is also against the spirit of our antitrust motor vehicle block exemption regime. And we've also calculated that actually, because of this patchwork of different national laws, the EU consumer is overspending 450 to 720 million of euros annually on the purchase of visible automotive spare parts. Next slide, please. There are, of course, it's clear that the automotive sector is not very happy if we would decide to liberalize the markets for spare parts and to harmonize it in such a way that in all member states spare parts would no longer be protected. They say that this would be alien to the IP system because it's their design. They should be entitled to protection. That it would also deprive them of a fair return on investment, and that it would, for that reason, also eliminate the incentive for innovation. Next slide, please. However, of course, those that are producing car parts and are not the right holders, of course, they're in favor for liberalizing the markets of spare parts and for abolishing protection. Their argument is that it would be against the purpose of design protection, which is actually to foster creativity through design innovation. Because currently, of course, there's no way to design around, and so it doesn't incentivize them to come up with new designs. This also, as mentioned before, would lead to the elimination of competition in the aftermarket, because only the right holder can produce them or its licensees. And it would lead to a lack of fair competition. This lack of fair competition would also lead to higher prices, because, of course, the right holder has a monopoly and therefore can ask higher prices. And also it leads to less choice for the consumers. Next slide, please. Like I said, we're also considering how we could approximate the two different systems, so the national laws and the community design system. Like I said, we are the main differences lie in the fact that procedures are currently not harmonized in the different member states. As an example, I can mention that, for example, the representation requirements on how you should file your design are very different in the different member states. Some say you can only have a maximum of 7 representations. Others say you can have 50. I mean, there's a lot of difference. Some are examining on novelty and individual character, others do not. Some offer invalidity proceedings at the national offices, whereas others, they don't offer this. So if you want to file for invalidity of a design, you have to go to court. And if we would be able to approximate the parallel systems, it would clearly lead to a less costly system, and this would clearly benefit those, especially those users that are filing not only in one member state, but across different member states. Next slide, please. Like I said, we will also try to consider how we can make the current community design system more accessible and efficient. The best way to do that would be to modernize the current representation requirements. As I mentioned before, currently you can only file a static representation, so 3D representations and video filings are not possible. I guess that Stefan will explain you a bit more about why this needs to change. Also, currently, what we see is that if you want to file multiple filings in one application, you can only do this for one particular class of the classification system, and this leads to many deficiencies at EU IPO because people try to squeeze in as many different designs as possible in one application that actually do not all belong to the same class. And it would be also good if we could adjust the fees, because the fee system is a bit complex currently, and for some the fees are too high. So the benefits of this would be that it would be cheaper if we can achieve all this, that it would be cheaper for the users of the system to get a right. And it would also lead to better use of the designs in the register. Because if, let's say, we would decide to increase renewal fees and lower, let's say, the registration fees, then it will be easier to get access to the system, but only those designs that are really used will be maintained. And I think this was the last slide. Could you go to the next slide? Next slide. Yes. So I've come to the end of my presentation. Sorry if I went a little bit over time. Of course, you have the opportunity, if you have any remaining questions, to ask them later in the Q&A session. Thanks for your attention, and I would like to give the floor back to the presenter.